Hey guys, so today we're going to talk about the grand jury here. Thanks guys for joining me. This is going to be mostly just an education session for you guys. I am going to provide a little bit of, obviously, where we're at, what we're doing, and so that you guys can know. But I want to empower you guys with some knowledge here so that you guys can, do your part from the bottom, working up, because, together we're gonna overcome this, guys. We got this. All day long, we got this. So let me start by saying there are fake accounts out there, you guys. They're fake accounts. These accounts, they use a different name. It's not Tanawa. My name is Tanawah, not Tawanah. Tawana. That's not my name. So, if someone contacts you and asks you for money, it's not coming from me. I have never, ever, ever contacted anybody asking for money. You guys are welcome to donate to the cause if you guys like my service, you want to see it continue. We would welcome that blessing, but we don't do this for money, right? My services are not for sale. And so I just want you guys to know that if anybody contacts you asking for money, that is not me. If anybody with a name other than Tanawa contacts you, look at the name. That's not me. And there's a lot of fake accounts out there that are scamming a lot of money from you guys. And I'm so sorry that that's happening, but I don't have any control. Facebook is refusing to close these accounts. We've contacted Facebook numerous times. They say that none of these accounts are in violation of community standards, which is obviously BS because they're using my name, my logo, and soliciting all of you for money for supposedly my services, and my services are not for sale. I've made that very, very clear, and I want to continue to make that clear. Now, one thing that's very dangerous about all of this is that, this could obviously be a government entity doing this because, if they send money out and then offer services, pretending to be me, then all of a sudden that becomes fraud if it were me doing it. And so there's a possibility that this could be government agents, and if it is, we'll cross that bridge when we get there. But I want y'all to know that, and I certainly need to put it out here and let you guys know that it's not me. I do not charge for my services. The things I'm doing it's not for sale. It's going to benefit everybody. Certainly this Article 3 argument that we'll get to here in a moment, this is going to help all of you. Right? One case, one argument can overcome all of them because it's all the same issue. If the state is barred from being the judge in a cause when the state is a party in the cause, then if we win one case, one argument, everybody wins, because by the establishment of the obligation that the Supreme Court has constitutionally codified to oversee the disposition of any dispute in which the state is a party, everybody who has been judged by a state in which the state was a party would receive relief. And that's what we're working on. We have one case to overcome, and we'll get there in a moment, okay? So just so that you guys know, there are a lot of fake accounts out there. They are trying to get money from you guys. Please don't get scammed. Please don't allow that to happen. But if you do, please don't blame me because there's nothing that I can do. Again, Facebook has refused to take these accounts down. TikTok's taken down probably 30 or 40 of them. It is what it is. But you guys, you don't have to pay me to do the things I'm doing, right? I'm here because God has compelled me to do this. I'm here because God has taught me how to do this, and I'm here because God has risen me up to do this. So, if you guys like the things I'm doing, then please continue to support, but only support the TER. So the only Cash App, Chime, Venmo, PayPal, the only one that we use is We Shall Be Free, right? This is the We Shall Be Free tour. So obviously our Cash App handles are they're all We Shall Be Free. That's it. There's no other ones. It doesn't go to any other account except for that one. That's the only one we have. Okay, so please, Jess and I, yes. If you want to support Jessica and I.
No, I'm saying they have fake accounts for me too.
Oh, okay. So, and there's also now fake accounts for Jessica as well, guys. So be aware that there's fake accounts for Jessica. Also, Jessica, if you guys want to see her continue to work with me, you guys want, well, whatever. If you guys want to continue to support the things that we're doing, it's We Shall Be Free. Okay, We Shall Be Free, and that money will get to us. That will get to the tour, and it will support the things that we're doing. The next thing I want to say is the number one way to make this information start moving very, very quickly here is to repost. That's single-handedly what will get this information flowing the quickest. As you guys saw on TikTok, we had one video last week that just did phenomenal. 3 days, 240,000 views. That's awesome. And so I appreciate that. But just so that you guys know, 97% of the people that viewed that video weren't even followers of mine. And we had somewhere around 4,000 reposts. So if 4,000 reposts, turn out to be 270,000 views with, 20,000 likes, that's awesome. That gets that information out there. But viral is 1 million in 3 days. Guys, we were a quarter of the way there. And so I appreciate that. But if you guys want to help make this stuff go quicker, and the information spread quicker, that's single-handedly going to be, the way that we can overcome this the quickest. And that's honestly what we're trying to do right now. So, that's why we're out here right now, you guys, is because we're trying to raise awareness as quickly as possible so that when the Supreme Court is re-impaneled on September 1st, that there's not going to be any way that they're going to be able to ignore this any longer. We cannot allow them to continue to ignore this. So that's what we're trying to do. And, we don't expect any of these city councils or county commissioners necessarily to change, although that would be nice if we found honorable individuals. But I don't expect that we're going to find honorable individuals because we can't find honor at the top with the governors, the attorney generals, and the Supreme Court justices. I don't expect that any of their followers will have any honor either. So we don't expect to find honor. But what we do expect to find is enough of them to start questioning it or start getting curious about it and saying, what do you want us to do? Because we are technically abridging the Constitution. So we're trying to light a whole bunch of fires. And, think about the strategy of our founders and forefathers, right? The people that we came from and that we learned from. If you want to predict the future, all you got to do is study the past. How did they defeat Great Britain? Well, they started a whole bunch of little skirmishes, right? I mean, a whole bunch of little fights, out in areas that were outside of the battlefield, and that's how they fought. It's called asymmetrical warfare, and that's what our founders did. So, if we want to defeat England once again, like we're trying to with the whole bar association, everything else, if we want to do that, well, let's take a look at our past and see how they did it, because they were successful. We will be too. We need to be more annoying to that tyrant than anything else, and that's what we're trying to do, right? We're making a lot of people mad by the things that we're doing right now, and that's awesome. That's great. That's exactly what we want. We want them to be mad, because when they're mad, that's when they're going to make mistakes. That's when they're going to do things that are going to be in error, and we're going to be able to latch onto. So we're building as many little fires as possible to try to annoy this tyrant and make them respond, not ignore any longer, because that's all they're doing. That's the only play that they have, is ignore what we're doing. So over here on TikTok, if you guys want to repost any of my videos, right? And by the way, we're about to release a video here in a moment of a service that we did last week in Smith County, Texas, guys. So we were in Texas this last week. We served the mayor of Dallas. That video's not out yet. We served Houston, the city of Houston at their city council, which was an awesome meeting because there were like 400 people in the audience, and they all started clapping and loving what we were doing, because most of them were there as advocacy groups for a couple of other issues, but they just happened to witness and oversee, what we had to say. And so it was a great response from them. which was awesome. So we'll be posting that video as well. Look for it. We were also in Smith County, Texas, and that's down in Tyler, Texas. And so we served the county commissioner there. That video we're about to release, you guys, you're going to want to look for that video. It's an excellent video. Once again, Jessica's doing a phenomenal job with getting these videos out. And then we also served city of Plano, Texas. And so that video is already out. You guys can see it. I'm going to go over, the things that I'm saying in that so that you guys can kind of understand, where we're coming from a little bit outside of just those city council meetings, because I want you guys to understand that. But as far as we're concerned, Texas is done. All right, we've now served the city of Lubbock. We've served Wichita County. We've served Dallas. We've served Houston, and we've served Smith County. So I think that as far as we're concerned, Texas is done. There's also been a number of other people that have served Texas supporting us, such as Crystal Salazar. She was out doing that, and then we also had a couple people that served down in McLean, Texas, down on the border there, as well as that same county there. So last week we had a good turnout with good coverage across the state of Texas. So Texas, as far as we're concerned, your attorney general's been served, your Supreme Court justices have been served, plenty of cities have been served, and now I would say plenty of counties have been served, because all of them are all part of the government entity. And remember, notice to agent is notice to principal. So once we serve the agent of the legislative branch, being a city of Lubbock or city of Houston, once we serve the agent of the legislative branch, even if it's the lowest level agent, it doesn't matter, that whole branch has been served. So all three branches of government in the state of Texas has in fact been served as of this moment. And I've also been in D.C. and sat down with the agents of Senator Cruz. So your United States Senator has also been served as well. All right. So TikTok, if you want to repost any of the videos, then you'll come down here to the bottom, right around this area. There's 3 dots. You're going to tap on this dot, and then there'll be a menu that'll pop up. You'll come over here into this area right here. There'll be a little yellow circle with arrows going in a circular direction. That's repost. All you gotta do is just tap on it. It's done. That will get it out into your feed. It'll share and get much more view and coverage of it. So please do that with as many videos as you can, especially if you think that the videos are of good content. I would say right now, get that Fox News interview out. That wasn't recent, you guys. That was a year ago. But nonetheless, good content within it. That's the type of information that we want to get out. So please share that Fox News interview that we did last Thanksgiving, and let's see if we can get that moving quickly. Right? All that we need is one good, solid news agency to pick up this story, and that'd be it. And I will tell you that Houston Chronicle was there, took me when we were in Houston and did our presentation there, and they took me out into the hallway, did an interview with me. We are praying that Houston Chronicle is going to run a story on this, and if they do, then God bless them, and we're good. So there's a lot of videos that are not out yet. Like, we've also served the city of Santa Fe, New Mexico. It's not out there yet. All 3 branches of New Mexico is done, right, as well. Idaho as well. We've done all 3 branches of government. We've done that. So California, you're done as well. So what we're doing is we're trying to come through, and we're trying now to serve the legislative branch, even if it's the lowest level, but the legislative branch. We have been to Alabama in a couple of places. We've done city of Huntsville and city of Birmingham, or county of Birmingham, Jefferson County. So we've done a couple within Alabama. We've not done Montgomery yet. Okay, guys, we haven't done Montgomery yet, but and I can't say that we necessarily will, but the state has been served. It's sufficient to have served the lowest of the legislative branch in order to get the legislative served. So let me just clarify that just a little bit here. So the executive branch would be the governor, right? And the governor's agent is the attorney general. So when we serve an agent of the attorney general, being an assistant attorney general, then the attorney general himself is served, as well as also the governor is served. So we want to get the executive branch served. Now, what we did with them was we provided an affidavit on behalf of one or maybe a couple actual applicants within the state that have been charged by way of information, not indictment. Okay, and so what we did there was we provided the affidavit, which is a criminal allegation or an allegation of crimes that have been committed by an actual victim. And again, this is called prima facie evidence. It's prima facie evidence for a per se crime because when it comes to government officials and constitutional obligations, all that we have to do is show that they had an obligation constitutionally codified and they didn't do it. And in doing so, all elements of their crime have been met. See, public officials, they don't get a finding of facts. They don't get a trial. In the case of a public official, all that you have to do is show that they had a constitutional obligation to do something. When they didn't do it, you don't have to prove that they intended to not do it or they willfully didn't do it. All you have to do is show that they had to do it. And when you do, they've already implicitly invited punishment in the form of perjury should they fail to fulfill that promise. And remember, perjury is a violation of public trust, meaning that you cannot be trusted by the public to do your job anymore. And thereby, according to Article 3 of the Constitution of the United States, you are discharged from your office when you fail to fulfill the promise that you made and in the constitutional obligations that you have. So this prima facie evidence is very simple, very straightforward. The Constitution of the United States of America, Clause 1 of Amendment 5 says you got to have an indictment by a grand jury. You didn't have an indictment by a grand jury because you chose to rely upon an inferior state statute that allowed you to do something different. And as a result, that inferior state statute is unconstitutional because it's contrary to the Constitution. If the Constitution requires an indictment by a grand jury before holding someone over for a capital or an infamous crime, then prosecuting attorney, when you fail to have a grand jury indictment prior to arresting someone and holding them over for that infamous crime, you have just acted unconstitutionally. You have just committed a crime, deprivation of rights under color of law. It doesn't matter why you didn't have the indictment by a grand jury. What matters is that you didn't have the indictment by a grand jury, despite the fact that it is required, enumerated, and codified in the Constitution of the United States of America. You see, the Supreme Court of the United States in 1884 came out in a case called Hurtado versus California, and they said, oh, state of California, you don't require an indictment in your inferior constitution. That's okay. You don't have to do one. It's fine that you charge by information, right? And so what happened there was that the Supreme Court of the United States, they removed the constitutional obligation that exists that's enumerated within Amendment 5, and they replaced it with their judge-made ruling, right? With their judge-made ruling. Now, a judge-made ruling is not law. Judges cannot legislate. We know that. That's why Clause 1, Article 1, the separation of powers codified in the Constitution, says that all legislative powers vested in a Congress of the United States, consisting of a Senate and House of Representatives, because judges don't get to legislate. They cannot amend the Constitution of the United States because Article 5, the special amending procedure, explains the way that you can amend it, and that has nothing to do with the judicial branch, nor the Supreme Court of the United States. They have no authority to alter, amend, or destroy any of the provisions or guarantees of the Constitution of the United States. That must be done by an authentic act of the people. And according to our founding father, George Washington, those obligations are sacredly obligatory upon all, individually and collectively, until changed by an authentic act of the people, right? Our founding father said that those obligations contained within the Constitution, and it stands at all times until such time as it's been changed by an authentic act of people. That is sacredly obligatory upon all, both individually and collectively. Guys, we are going to win this case. It's just a matter of making them have to hear us, right? They're ignoring us now. We want to make sure that they cannot ignore us anymore. That's why we have to make some more noise. So we serve the executive branch by going to the Assistant Attorney General, or in the case of Vermont, directly to the Attorney General. We gave them an affidavit of affected victims within their state of this particular crime, and we said, basically, these are crimes that are being committed by your agents, because the prosecutors all work for the highest law enforcement officer of the state, because all prosecutors are the highest law enforcement officer of the county, so they certainly work for the highest law enforcement officer of the state. So the prosecutors work for the Attorney General. If the Attorney General wanted to correct the unlawful acts, all they have to do is direct their agents to act in a lawful constitutional manner, and we would be able to resolve this, right? But if they don't want to correct the unlawful acts of their agents, then that means that they are permitting it, sanctioning it, and leading it, right? They are responsible for it now. And what's important there is that means that the Attorney General is now opposing party to all of you. No Attorney General of the state can now represent the people on this issue because they're all opposing party to this issue by their failure to take action and lawfully, constitutionally correct the criminal acts of their agents, right? We now have 48 Attorney Generals that are now opposing party to the people and cannot act on behalf of the people in this case. See, what I'm trying to do is I'm trying to create a position, a new prosecutor, a new Attorney General that has to come in and adjudicate this on behalf of the people by removing all of the criminals from being able to do it. That's the position I'm creating, and I am creating it so that I can step in and fill that role on behalf of all of you, right? I'm going to prosecute this. I'm going to be the private Attorney General because the Attorney Generals of the states are unwilling to do what is necessary to obey the Constitution and the will of the people. But this is a very, very slow, tedious process. So we served all of the Attorney Generals. They're all opposing party. When they failed to take action to correct the unconstitutional acts of their agents, the prosecutors, then we had to go back and we served the other half of the criminal conspiracy, which is the judicial branch. We went back to the clerk of the courts, all 48 state Supreme Court clerks, and we served them. Now they are the agent of the Supreme Court, right? Like for instance, the where was it? New Hampshire, and also Maryland. Maryland told us, oh no, we don't accept this because if you want to serve the justices, you got to go through the Attorney General and serve the Attorney General. It's not true. That's BS because the Attorney General is executive branch. If you serve the executive branch for the judicial branch not served because the Attorney General is not the agent of the Supreme of the justices. So some of these things you have to understand that they're going to push you in a different direction because that mitigates their liability. So that's why I served all of the clerk of courts of the Supreme Court, because they are the agent of the Supreme Court. You don't take that to the Attorney General and expect the judicial branch to be served because those are two different branches of government, right? But that's what they'll try to make you do. So we went back and we did the same thing. We served these 48 state Supreme Courts with notices as well. The same affidavit, the same victims, and the same request that you direct your agents, the judges, to act in a lawful constitutional manner and correct their unlawful acts. If you don't, then you become complicit in it, which means that no judge in any state can oversee the disposition of this dispute because they're all opposing party by their failure to correct their unlawful unconstitutional acts. Now, another thing is that I'm not fighting this in a courtroom. Why would I go into a courtroom and fight within a courtroom playing by the rules of a system that doesn't adhere to its own rules? Absolutely not. Why would I go to criminals and ask criminals to stop committing crimes, right? What I'm doing here is I'm providing the notice to show their criminality. So the laws of criminal conspiracy with regard to public officials, it doesn't say that I need to file anything in a court to make this happen. What it says is that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined as defendants in the action. So I don't need to have a court record, right? Because all I have to do is notify them of the criminal acts. And if they permit the criminal acts to continue once notified, I don't need a stamp from a damn court saying that I served them. All I have to do is show they were served. And I did. I served all of them personally. I personally went through and I served all of these attorney generals, all these Supreme Courts. I served them. I know that and now they've been provided notice. Once provided notice, you have a choice at that point. You can either, one, stop committing the crimes, or two, continue doing those crimes, and then that goes from negligence to willful criminal conduct, right? So once we notified them, the fact that they continued to take action, in fact, the county of Jackson, Alabama, right? This is Birmingham, Alabama. So we served Jefferson, Alabama. We served the county commissioners there. in a very, very arbitrary way. In fact, we were lucky to even be able to do it because there wasn't supposed to be any public hearing on that meeting. We just happened to be there early because we were going over to City of Birmingham right afterwards, and we just figured we'd show up a few minutes early and go to this meeting. Well, what's funny is that they went through all the meeting, and we were just standing on the side observing. These videos are available. You can go on to TikTok, Facebook. These videos are available. And so the commissioner, the primary judge, as they were sitting there at the table and they're wrapping it up before they adjourned. Now, this is key. Before they adjourned the meeting, because before adjournment, it's all public record, right? It's all on the public record. So the judge that was leading the meeting, he looked over at the county prosecutor and said, "Hey, Joe, is there anything you want to say?" And Joe says, no, there's nothing I want to say. But there's this guy standing over there with a coffee, and he hasn't offered to share anything. Kind of wondering why he's here. And so I took the opportunity to say, well, this is obviously a great lead-in. Let me tell you what I'm here for. I'm here because we're about to serve the city, and then I'm a civil rights advocate, litigator out of Washington, D.C. And then Joe, he said, Joe again is the county prosecutor. He said, well, you're not planning on suing anything against anybody on this side, are you? And I said, well, this is another great lead-in. Thank you, Joe, for that question, because if you don't mind, let me explain to you what I'm doing here. And I went in and I started explaining everything. And it was an excellent volley of questions and responses. You guys, if you haven't seen that video, go out and watch that video because it was an excellent video. In fact, the sheriff of Jefferson County, he actually piped up as well and said, oh, yeah, it's in the Constitution. You got to have it indicted by a grand jury. You can hear him in the background actually say that. Oh, yeah. The sheriff said it. And so, and there was another point in which the judge who was leading the commission meeting, he tried to stop it. And he said, hang on. I'm going to end this right here because the news was in there listening to this. And he says, we're going to end this right here because this isn't going good for the county right now. Because I had just said that, if the county is paying their sheriffs to go out and, make arrests unconstitutionally, then the county is implicated in all of this because you guys are paying for those crimes to be committed, those illegal warrants to be executed. And so he tried to stop it, and I would have absolutely stopped. I mean, because, I have to maintain decorum to avoid, arrests on what I'm doing. So maintaining decorum. But the good news is that Joe immediately spoke up and asked another question, which allows me to lead right in. And what he said, what Joe said was, he said, yeah, but the city of Birmingham, we don't have any felonies. Therefore, and I said, oh, no, you guys, the city of Birmingham is paying the police to go out and perform these arrests. And if those arrests are based upon an officer who's relying upon an inferior state statute that deprives a person right guaranteed by the Constitution, then that's where it comes from. And that's when the sheriff actually piped up and said, yeah, he's right. But what Joe said, the judge that was leading the commission meeting, what he said was, when I said, yeah, but if you are locking people up in a county jail, then that means that the county is complicit in it because you are holding people over unconstitutionally and illegally because there was no authority to perform the arrest because it was in violation of the Constitution. And that's when the judge who was leading that meeting, at that commission meeting, he immediately spoke up and said, that's not our problem. That's someone else's problem. And that's the type of information I want you guys to hear. Like, this is how they feel about our rights. We had a judge who was leading the commission meeting, who I just said, all these people in your jail are being held unconstitutionally, which they agreed with, even the sheriff agreed with. And he said, oh yeah, but that's not our problem. That's someone else's problem. It is your problem because you're paying for those people to be housed in that jail unconstitutionally because they've been arrested without lawful authority. That is your problem, county commissioners. That is your issue. So, but that's a response that, that's typical from these public officials, where they either, one, don't want to do anything about this, or two, they're just going to try to play it off as someone else's problem. And that's not how a criminal conspiracy for public officials work. This is what I'm trying to show you guys, is that the laws of criminal conspiracy state that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined dispensing action. That judge who was sitting on that commission, leading that county commission, he said, not my problem, someone else's problem. There isn't a single jury in the world that I would not be able to find 12 jurors that would disagree that he couldn't have done something to prevent this criminal conspiracy from continuing, right? And that's the problem we have, is that every single public official is responsible. The moment that they have been informed and notified of a criminal conspiracy, they must take action. And if they do not, willfully or negligently, it doesn't matter, they can be joined as defendants in that action. They are guilty, because if I'm a public official and I'm aware that a crime is being committed and I fail to do anything to stop that crime from being committed, I may as well be the very person pulling the trigger, because I knew about it and I continued to allow it to happen. And that's why we have to get out here. That's why we have to serve these people. That's why we have to notify them. And the notification is simple. Here's an affidavit, an actual prima facie affidavit, or prima facie evidence of this per se crime that you can't deny, because the Constitution says it. They didn't do it. So what are you going to do about it, right? You're going to correct your agents to obey the Constitution, or are you going to permit the unconstitutional acts to continue? Thereby, you are now implicated in it. So we went back and we served all of the state Supreme Courts. They're done, right? There's 3 states left we have to do. That would be West Virginia, Hawaii, and Alaska. Guys, Hawaii and Alaska are not going to happen unless we get the funding to be able to do it. We can't drive to Alaska and Hawaii, but that doesn't mean that they won't have to fix their unlawful acts too, because I know that they are serving arresting by information as well. There's no denying that, right? So we know that the conditions remain the same in Alaska, Hawaii, but we can't personally go there because we don't have the funding to do it. So unless we get the funding specifically to do that and to go on and do those services, I won't be able to serve those. But we will get West Virginia served. I promise you that West Virginia will be served. So we went through and we served the attorney generals and the Supreme Courts, notifying them that their agents are committing crimes and asking them to please correct the unlawful acts. They didn't do it. So the next step is, what we're doing now is, there's a third branch of government. It's the legislative branch. We got to get the legislative branch involved now, because the legislative branch is sitting back and they're saying, oh, well, we don't want to get involved in this. This is too big of a deal, right? So we're going to abstain, and they're ignoring it because they're not actually a part of the criminal conspiracy, right? If it's the prosecutor who is relying upon an inferior state statute to go out and charge someone improperly, right, with the improper charging instrument, that's unconstitutional. When he takes it to a judge and says to the judge, I'd like you to hold this person over, that judge is implicated in a criminal conspiracy now to deprive of rights, because he's relying upon the prosecutor who relied upon an inferior state statute to deprive a person of a right guaranteed by the Constitution. Now the judge is a part of it. Then when the judge signs that warrant and hands it off to a sheriff's deputy and says, Sheriff, please go out and perform this arrest, that sheriff also is a part of it, because that warrant derives from the judge's abuse of power, because he relied upon the prosecutor's abuse of power, who relied upon an inferior state statute to deprive someone of a right guaranteed by the Constitution. So when that sheriff then goes out and performs and executes this warrant that is unconstitutional, that arrest is now unconstitutional, which means that now the crime of kidnapping has occurred, and it's a federal kidnapping offense again, because they're holding this victim over for ransom in the form of bail. So all of this is absolutely facts, 100% facts. There's no denying this. In fact, none of these agents are denying it. In fact, the Attorney General of Rhode Island, he responded by saying, yeah, we're aware that these statutes are unconstitutional, but we're going to continue to enforce them until such time as we are directed otherwise. That's what the sitting Attorney General of the state of Rhode Island right now says, that, yeah, we're aware that what we're doing is unconstitutional, but we're going to continue to do it until someone tells us to do otherwise. And that's not a very good position to take there, because that establishes mens rea, Mr. Attorney General, because now you're aware of constitutional acts that are being unconstitutional acts or conditions that are in place, and yet you're going to continue to act unconstitutionally, which is, that's mens rea. It's a guilty mind. You acknowledge the fact that you're aware these crimes are being committed. But the sheriff should fall under the executive branch, but interestingly, the sheriff's department would be an unconstitutional department because the sheriff's department is actually a law enforcement branch of the judicial branch. And when did the judges get involved in enforcing the law, right? When a judge orders your arrest because you did something in the courtroom, right? Because whatever, you contempt of court. How can that judge order your arrest when the arrest order must come from the executive branch? It seems to me, Judge, like you are acting as a lawyer while sitting on the bench, because only a person can do that. And yet, when you order an arrest in your official judicial capacity, you're acting as an executive officer, not a judicial officer. So, these whole contempt of courts bullshit, it's not valid because the order for arrest must come from someone within the executive branch. It can't come from the judicial branch. That judge can't order your arrest, right? Because that would be a separation of powers issue. But nonetheless, so we have the executive and the judicial branch that are tied up into this criminal conspiracy. Well, the legislative branch is sitting back here going, that's a big deal. I don't want to get involved in that, right? Because we're not a part of it. So we're just going to sit over here and ignore and do nothing and, and pretend like we don't see anything or don't know anything. We have to get them involved. 1 second, guys. I got to plug in this phone. It's only got 4%. 1 second, guys. Hang on. So we have to get the legislative branch involved in this, right? And that's what we're doing now, is we're going out, we're serving the lowest level of the legislative branch, which would be the city councils, county commissioners, and we're informing them that they are paying people to commit crimes. That's how we get them involved. That's how we bring in the legislative branch. Because again, if the city of Birmingham is paying for the police to do their work, right? Because the city's paid for the police to do their job. And if those police are acting unconstitutionally, depriving people of rights that they're guaranteed by the Constitution, then that means that those police are committing the crime of deprivation of rights under Colorado law, Title 18, subsection 242. What 242 says is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. So if the police are performing an unconstitutional arrest because they are relying upon an inferior state statute that deprives a person of a right that they're guaranteed by the Constitution, they just committed a crime. Every single time they perform an arrest, right? Well, a felony or a capital crime. We'll deal with infamous crime, non-infamous crimes in another way. But right now we're talking about infamous. So an infamous crime is any crime punishable by more than 1 year imprisonment in a penitentiary. All right. But if the city of Birmingham is paying the police to do their work, to do their job, and they are committing crimes in their job, then city of Birmingham, you are paying for those crimes to be committed. Make sense? All right. So an emolument violation is when you pay a public official to commit a crime. You cannot pay a public official to commit a crime. No person can profit off of their illegal acts, right? This is a fundamental principle of our Constitution. You cannot profit off of your illegal acts. So if the city of Birmingham are paying police officers to go and commit crimes, then what we need to do is we need to go to the city of Birmingham, to their council, when they're having a public hearing, when it's on the record, and we need to inform them that they're paying people to commit crimes. What that does is that ties the legislative branch in. Now the legislative branch is involved in it because we have provided them knowledge of this crime that's being committed. Remember, any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined and dispense the action. So there's nobody that would deny that the city council can do something or aid in the prevention of these crimes, especially when I tell them how to do it. Either stop paying them or direct them to act in a constitutional manner. Because if you continue to pay them even one more time after providing this notice to you, you are now permitting those crimes to continue. This is how we tie the legislative branch in, right? So we're bringing them in, right, through the service to city council, county commissioners during public hearings on the record. These are on the record. In fact, commissioner meetings are known as courts. So I'm going into the court and I'm providing a public hearing, informing them of these crimes. And what's even better is that they can't even respond to the things that I'm saying. Because when we talk about an issue that's not part of the agenda, according to the law, they can't respond to anything we're saying, which means that this allegation goes unrebutted, you guys. It means that it means that what I say is controlling the narrative, and they can't even rebut that narrative. They can't even rebut it. So this is a great situation for us, because if we come in and we talk about a non-agenda item, we control the narrative. And what we're saying is, this is what the Constitution says. This is what you're doing. That is unconstitutional. You guys are paying for these crimes, so you either stop paying them or you direct them to act in a lawful constitutional manner. And if you don't, then criminal sanctions can be brought against you, right? Very, very simple. And so the reason why we're going to the county commissioners now, because remember the separation of powers here, okay? City pays for the police to do their job. Police are performing unconstitutional arrests. The next is the counties. The counties pay for the jail. The counties pay for the sheriff. The counties pay for the court, all right? Because it's a county court. So if the county commissioners prepare the budget for the sheriff's department, and the sheriff's department are going out and executing warrants based upon an unconstitutional warrant issued by a judge because of the unconstitutionality of the actions of the prosecutor, that means that sheriff is now implicated in it, right? Because he's arresting people without lawful authority. Because lawful authority requires, according to the Constitution, the indictment. Where's the indictment? You're not making sure it's there, and as a result, you are now part of criminal conspiracy. So the county commissioners, they pay for that crime to be committed, because that still is deprivation of rights under Colorado law. That is still conspiracy to deprive rights, and it's also kidnapping now, because that sheriff did not have lawful authority to be able to arrest them and then put them into a county jail, right? So that jail itself is housing people unconstitutionally, because those people could not be arrested under our Constitution and in the procedures and processes codified within the Constitution for the initiation of an adjudication of crimes. And then they're bringing them into a county courtroom, and all of the resources associated with that county courtroom is now prosecuting someone unconstitutionally because that arrest was unconstitutional. And if the arrest derives from an unconstitutional act, everything coming from that unconstitutional act must also be unconstitutional, because it is all tainted by the illegality of the way in which it was obtained. Nothing that they do after the moment that they perform an unconstitutional arrest can become constitutional. That is a maximum law. Any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. It doesn't matter how long it's been. Doesn't matter if you've already been prosecuted. Doesn't matter if you pled guilty. None of that matters. All that matters is, did they follow the proper constitutional requirements, the procedures and process? If they did not, then what they've done is unconstitutional. No one is arguing that point. Not even the Attorney General of Rhode Island or the Attorney General of Washington. They are coming out and declaring that they're fully aware of these issues, but that they're going to continue to do it, which is another very, very good point. Because there's another service that we did. It was a service to the city of Pasadena. Now, Pasadena is a huge city, right? They do the Rose Bowl. They're a suburb of Los Angeles. They have like $180 million a year police budget, like just a ridiculous budget. So we served their city council there. And when they wouldn't allow me to speak, because they let Jess speak first, and then they didn't like it. And so then they shut down and they wouldn't allow me to speak after that. But what's interesting is that, and we haven't posted this video yet, we'll have it up before long for you guys to be able to review. But what they said was, one of the city council members, after we were done speaking, he came out and he said Mr. Downing, which I don't think that anybody would confuse Jessica for a man, right? They said Tanoa Downing, and then all of a sudden Jessica speaks under my name, and then this guy addresses Jessica as though it's Mr. Downing, which leads me to believe that they had some advanced notification on who was coming through, because he said, Mr. Downing, although he's passionate, he said this issue has well been addressed, and the city here is not in a position to challenge state law with regard to hiring, firing, or employment of police officers. Right? That was his response on the record after we had spoken. Now, what I want you guys to know there is that listen to what he said. Okay, he said that the city council is not in a position to challenge state law with regard to the hiring, firing, or employment of police officers. What happened there is that, one, he acknowledged the fact that he's aware of what we said. He understood what we said, but then the third is that he is not in a position to challenge state law because he's unwilling to enforce constitutional law, right? That can be seen from two different perspectives. It can be seen from the perspective that he's not going to challenge state law, but he's not going to challenge state law because he's unwilling to support constitutional law, right? That's what he said. So if you're unwilling to challenge the unconstitutionality of your state statute, and you're going to continue to obey an unconstitutional state statute, then that means that you are aware that you were acting unconstitutionally, Mr. Council Member. And what's even more interesting is that his name was Madison, Councilman Madison. And you guys, as we all know, James Madison is considered the father of our Constitution. He wrote the Bill of Rights. He's the author of the Constitution. So a man that bears the very father of our Constitution's last name refused to obey that which James Madison created, 3 separate but equal branches of government, governed by the obligations codified in the Constitution for the United States of America. So we see a breakdown of what James Madison conceived of his system of government that the people created when we adopted the Constitution of the United States on September 17, 1787, and this is being done by the very person that bears his last name. So now it's very interesting that it was that way. But all right, so that's what we're going through, and we're serving city councils, county commissioners. Now, if you guys want to help, we could use the help. Absolutely. Right. If you guys want to get involved in this, you want to go out and serve your local city council and county commissioner, guys, listen, I've done this 40 times now. Like, you guys can see the videos. As long as you maintain decorum, they can't do anything about you speaking there. All right. Decorum is one, you don't attack any one of them directly, right? You don't come out and start talking about, oh, that prosecutor, or oh, that sheriff. You can't do that. That you must not bring in any single individual. That's decorum number one. And number two, you can't talk about any specific. So sometimes they have agenda item, sometimes they don't. But when they have an agenda item, all you have to do is find anything related to budget, right? Because what you're doing is you're saying, you guys prepare the budget, and that budget includes money that's going to go to pay people to commit crimes. And now you can be included within the agenda item, right? And as long as you understand that, you can speak on that, and they can't deny you. So you don't got to worry about getting arrested by going in and doing this, right? But if you guys want to help do that, then we have a two-page script that you guys read. Okay, 2 pages, and it's you could easily read it within 2 minutes, 2.5 minutes. 2 minutes is pretty tight. I think that I took 2.5 minutes when I did it originally at City of Fairfax. But we took the City of Fairfax, we reduced what I said into writing, and provided that as a script. You guys can go and you can download that script from justicewithoutlimits.org. So you can go out to justicewithoutlimits.org. You can download that 2-page script, and then there's a 4-page notice, right? That's also available at justicewithoutlimits.org. And you can go out and you can download the notice, and you provide that. Once you finish reading the script, then you can provide that notice to the city clerk, right? And that's part of the script is, I have a notice here I'd like to provide to put on the record. And once that notice is on the record, that's it. You guys are done, right? And that's all that's necessary to incorporate and enjoin the legislative branch into this. Notify them that they are paying for these crimes to be committed, and letting them know that either one, you guys stop this, or two, you are absolutely a part of this now. Okay? So we're working up in the legislative branch. With the executive and judicial branch, we started at the top, fighting crime from top down. So we went to the top, and then we served automatically all the way down. Because notice to agent, is notice of principal. So if the principal is the attorney general and we served an assistant attorney general, notice to agent is notice to principal. But notice to principal is notice to agent. So once the principal was notified, because we notified the agent, then when the principal failed to correct the unlawful acts, all of their agents are automatically notified. We don't have to go to any prosecutor or judge across the state because their boss is permitting it to continue. They're all notified. They've all been served. You don't have to do any more. Legislation, though, however, we're working up from the bottom because ultimately we're gonna probably need to have to do a remonstrance for this. So a joint session United States Congress remonstrance, it takes a lot to make that happen, right? Congress isn't just going to allow me to come in and talk about this issue with them, right? But that's what would need to happen. So in order to do that, we've got to work our way up to it, So, so we're starting at the lowest level for the legislative branch in order to work our way all the way back up to the top, right? So ultimately where we're going with this is to return to Washington, D.C. for a joint session remonstrance to be able to present this issue to United States Congress, to have Congress correct the unlawful acts of the judiciary. And so that's why we have to work from the bottom up, because we have to raise enough noise in the legislative branch that the highest, the United States Congress, will invite me in to testify to the Judiciary Committee and then ultimately to a joint session to address this issue. This is a huge case. This is a huge deal. Now, we don't expect necessarily for them to change it, but just as Sun Tzu said in the book, The Art of War, that the first step to victory is you must break up the alliances and pit them against each other. And that's what we're doing, right? So if you look at my strategy and what I've done, first off, executive branch, when I served all the attorney generals, I said, judges, judiciary, you guys are complicit in this because of your negligence, but it's the prosecutor that's bringing the incorrect charge and instrument, all right? Prosecutors are relying upon a state statute to bring the incorrect charge and instrument. Judges, you are absolutely implicated in it due to your negligence, but you're not the one actually that's the problem. It's the prosecutors that's the problem. Now that puts pressure from the judiciary for them to see a way out. So then they look over at the executive branch and they start to put some pressure onto them, thus the Chevron ruling and so on. But they put pressure over onto the other branch. So we manipulated one branch of government to put pressure on the other branch of government to say, oh no, you don't get to do whatever you want, executive branch. You don't get to write your policy and say it's not clear whether I have to have a grand jury indictment or not, because you don't get to amend the law. That's what Chevron was all about. So we pitted one branch government up against another branch government by going out and having that narrative. Then what we did was we changed the narrative up. So then I pointed out when I went out and I started serving all the Supreme Courts, the narrative changed. Because now I'm serving the highest judicial officer, and what I said across the board, you guys go back to my videos, right? What I was saying then was, judicial branch, you guys are the ones responsible for this because the Constitution says no person shall be held to answer for a capital or otherwise infamous crime. And who makes a decision to hold someone over? That'd be the judiciary. That'd be the judge. The judge makes a decision whether or not to hold someone over. Prosecutors, you can bring the incorrect charge and instrument. You can do that, but judge, it was your job to make sure that the proper charge and instrument was in place. You didn't do it, therefore you're committing the crime. Now, prosecutors, executive branch, you guys are implicated in this. Yeah, you were bringing the incorrect charge and instrument, but you didn't commit the crime. The judiciary committed the crime, right? So I changed the narrative. We went one way, and then we switched over here because then we needed, once the judiciary pitted itself against the executive branch and said, oh, you guys are going to take the fault for this, right? Just like he said, we're negligent, but we aren't the ones, bringing the charge and instrument. You guys are. Then we had to switch it up because now we got to pit the executive branch against the judicial branch. So that's when we went back and we said, oh, no, it's the judges. Judges are committing the crime. Prosecutors, you were implicated in it. You're negligent, but you have a way out. So we gave them that opportunity, and that's when we saw the DOJ memo come out, right? Because the DOJ memo said all these judges are all unconstitutional. They're all acting illegally, and we're not gonna protect them anymore. right? That was at a very high level. Once again, that was the executive branch's response to, oh, we got a way out because it's not us that's committing this crime, it's the judiciary that's actually committing the crime. So we got those two branches of government pitted against each other, between serving the executive branch, the Attorney General, and the Supreme Court. We got them pitted against each other, but then we tried to bring the legislative branch in. We couldn't get them to come in. They were abstaining, refusing to do anything, ignoring this, right? I went to all the United States senators, most representatives, and they all said, oh, that's a state issue. We abstain. We don't get involved. So in order to get the legislative branch now involved, because obviously the two co-conspirators, the judiciary and the executive, they're not going to stop doing what they're doing, because in order to do so, they'd have to admit that everything they've done is illegal and a crime. So now we had to bring in this third branch of government. We had to get the third branch of government involved and pitted against it. But in order to do that, we have to make them a part of the conspiracy. Whether they want to be or not is irrelevant. We had to figure out a way to make them a part of it, to put them, to have some skin in the game for them. And the way we're doing that is through this service, notifying them that, you know what, legislative branch, maybe you're responsible for all of this because you're paying for all of it. And if you didn't pay the judiciary, or you didn't pay the executive branch, you didn't pay the Attorney General, or you didn't pay for all these prisons and federal funding grants for all of these jails, if you didn't pay for that, there wouldn't be any of this crime, because no one's going to do anything without being paid. So maybe the legislature is actually the one responsible. Maybe the judiciary is complicit in it. Yes, they're violating the Constitution. Maybe the executive branch is complicit in it. Yes, they're bringing the incorrect charging instrument. But maybe it's the legislative branch that's the one that's really responsible for all these problems, because they're paying for it. And if they didn't pay for it, then none of this would happen, right? So that's how we bring them in, guys, right? If you're paying for crimes to be committed, then maybe you're responsible for all these crimes. And now we got all three branches of government pitted against each other, trying to figure out who's going to be responsible for this, right? Because that's what we want, right? We just want them to address this, and we don't care where it comes from. But one of these three branches of government had better step up and address this, or else they're all three now implicated in a criminal conspiracy to undermine the laws of the United States. And every single one of them is committing perjury. Every single one of them is committing capital crimes. And every single one of them is responsible for every single crime committed by the entire conspiracy. Guys, how many crimes do you think that we could add? Hell, I have 2 million, almost 2 million criminal affidavits. Every single one of them is a capital crime, from a judge, a prosecutor, and law enforcement officer, perhaps even multiple judges, prosecutors, and every single one of them. I mean, every single one of those is a separate capital crime, right? And yes, it may not say legislatures, but guess what? Legislatures, you're now implicated in it, because you have a duty to not pay people to act unconstitutionally, and you're paying people to act unconstitutionally. So if the United States Congress is going to ignore it, we're going to come up from the bottom. We're going to create as much pressure as we can so that the bottom pushes me up into the top. All right? So that's where we're at. Serving the bottom, getting the cities and counties served. Eventually, we're going to go into the state level and notify the state legislatures. And then that should be enough to be able to push me up into the United States legislature, because eventually they're going to have to address this. But we have to keep this pressure up, okay? So what is a grand jury, you guys? There's a great case if you guys want to learn a little bit about the jury process. According to Blackstone, it's a two-part process. It's made up of a grand jury and a petit jury. Don't get those two things confused. Those are two completely different functions of the same process, okay? So there's a case called Duncan versus Louisiana. I believe it was 1968, sometime around in there, that describes the two-part process, right? It was actually making sure that you always have a petit jury no matter what, for any crime being committed. That's what that way. It was the incorporation of the Sixth Amendment right to a jury and one's peers. But if you want to go out there, it talks about the grand jury, talks about the two-part process, how they're both essential. Blackstone describes it. So The point of the grand jury is it's the beginning, okay? It's not the end, it's the beginning. The petit jury is the end. So a grand jury, by definition, is 16 to 23 people that are impaneled for a long period of time, sometimes 18 months. I mean, a long period. They're impaneled for a long period. And their sole job is to determine whether or not there is sufficient probable cause to assume that a crime has been committed, right? They don't determine guilt. All they do is they look at the evidence and they determine, yeah, I think a crime was committed, and now it can go into a criminal adjudication. Okay? It can't, there's no crime committed unless a grand jury determines that a crime has been committed. Now, you guys know that one of my degrees, I have a master's in forensics. I specialize in forensic accounting. That's why I'm very good at this particular issue, is because this is an accounting-based system. It's an economic-based system. Okay? This is all about accounting, and it's an accounting flaw. The reason why it's an accounting flaw is this. Now, guys, follow me here, okay? Follow me here. Our founders and forefathers who framed our Constitution were simple but wise men. They weren't establishing complex principles or elaborate institutions to which only men of rich or educated or noble statuses could understand. You see, they were simply trying to create a legal accounting system which adequately and fairly reconciled the debt owed to society. If you choose to violate the law, you incur a debt to which you are charged and then called to account so you can pay the debt. Those are all very simple accounting terms. Now, the way that debt normally works is, if I want to purchase something from a store, a bill is first generated, which I sign and accept. Then my account gets charged and I incur a debt to which I then have to pay. This is a very simple method for transactions to which anyone can understand. However, if the store charges a person's account without billing them first, that is called fraud. You must always bill before a charge is generated. Now, the way all this applies to this case is that an indictment is called a bill. So absent an indictment, people are being charged fraudulently because they're not being billed first, right? The bill is the first step. If you want to charge someone and charge in an accounting-based system, the first thing you have to do is you must generate a bill, right? You must give them a bill of what it was that they purchased. And then once the bill is delivered, then you can charge them. But you can never charge without billing first. So absent a bill of indictment, the charge is fraudulent because it's not being billed first. That is an accounting flaw. That's an accounting error. That's why all these charges are all fraudulent, because none of you are being billed first. You must have a bill of indictment. Now, we could take this one more step, okay? Because I want you guys to understand the constitutional issue here. According to our Constitution, Article 1, the only branch of government that can create a debt or a tax against the people is the legislative branch. The executive branch and the judicial branch cannot create a debt or a tax against the people, because the Constitution requires that it's the people that create the tax. In a courtroom, all three branches are represented. The judge represents the judicial branch. The prosecutor represents the executive branch, and the jury represents the legislative branch. That's why a grand jury must create the bill, because the legislation or the legislative branch is the only branch of government that can tax the people. So when a prosecutor brings a information, that is a prosecutor that is charging your account, creating a tax against you without constitutional authority, because the executive branch cannot create a tax or a debt against the people. When you walk in that courtroom and that judge decides that he's going to issue you child support, right? That is a tax or a debt against you that's originating from a branch of government that has no authority to do it. Guys, again, the Sixth Amendment preserves your right to a trial by jury. The Seventh Amendment preserves your right to a jury trial for any matters over $20. Why is that? Because the judge and the prosecutor, or the judge and the three-letter agencies, cannot create the tax against you because it must come from a jury. The legislative branch must determine. So in all matters of equity and law in greater than $20, it must come from a jury, because only the jury, the legislative branch, can create that debt against the people. So if you're in a courtroom, right? If you're in a courtroom and you're going through your right to travel, and I'm not going to go into right to travel, I'm just going to say this, okay? That if you're going through a right to travel issue and they've charged you $200 for a fine for speeding, I'm going to say to you, who created that debt? Was it not the officer that said that you now owe a tax, right? Is it not the officer? And who does the officer represent? Well, the officer would represent the executive branch. Great. That $200 is greater than $200, and that executive officer cannot create the debt against me because it must come from a jury. That's why the Seventh Amendment says that the jury trial is reserved and protected, you guys. Now, I'm not telling you guys that this is the way that it works. I'm telling you guys this is the way it's supposed to work, okay? This is the way our system was designed to work. I'm not saying that it's how it works, but I'm telling you this is how it was supposed to work, okay? And this is how we're going to make it work, right? Because those that are currently doing it and administering it are doing it improperly, unconstitutionally. There's nothing that they can do to make anything that they've done constitutional because Constitution requires this. It's a very, very simple. Most every one of my arguments are all a separation of powers issue. I mean, even James Madison said that when you consolidate powers into a single set of hands, be it judicial, executive, or legislative, when you consolidate powers into a single set of hands, that's the very definition of tyranny, right? We have nothing to be concerned about the judiciary if they are only doing the judicial duties. But when the judicial branch starts creating law, case law, right, doing a legislative act, or when the judiciary starts ordering people to be arrested like they do every day in your courtroom when that judge says, bailiff, arrest him, right? Because, judge, you don't have the authority to do that, right? You don't have the authority because that must come from the executive branch, not you. But when you, judge, believe that you have the power to arrest, you have the power to create law, well, that's a consolidation of powers into a single set of hands. Therein lies our issue, right? These out-of-control rogue judges that have absolutely no authority because they're overstepping their limitation of powers codified in the Constitution of the United States. There's nothing that they can do to fix what they've done, right? Because it is all unconstitutional. So most everything I argue, most all my points are separation of powers issue. We have a separation of powers with these powers specifically localized, three separate but equal branches of government with specific responsibilities and duties, and as a result, that's where they are. So yes, I understand that that's why I say that when you go into the courtroom, I'm not saying this is how it works. I'm telling you how it's supposed to work. So, with this information, I'm hoping that you guys, you go out. I mean, with this knowledge that I just gave you, with the separation of powers issue, that only the legislative branch can create a tax or debt against the people because the first Article 1 says that all legislative or all tax must originate from the legislative branch. Therefore, I have to have a jury or else this tax or this debt is coming from a branch of government that doesn't have the authority to create it, constitutional authority to do it. I'm hoping that you guys will take that knowledge and go out and go and fight this, because this knowledge is valid. But that brings me to another point here. And that is that again, don't expect to get relief in the low courts, right? Don't expect to do it. Because the reason why these state judges are acting unlawfully is because their leadership taught them to do it. Because their leadership is doing it themselves. So as long as the Supreme Court of the United States continues to ignore the Constitution and continues to not follow and obey the Constitution, then you can expect that their followers or their agents are also going to be not following the Constitution. That's why this fight is at the top. We've got to fight from there. So So there's something known as the doctrine of duties and rights. The doctrine of duties and rights. So this is something that most people don't understand. You know, when I say to you, where do you get your rights? You say, well, they come from God. They do. You're right. Your life was given to you by God. But the way that we create your right is by what we call a duty. Okay, a duty. So I know a lot of people might have a problem, but follow me here. Okay, so in the natural state of man, right, as a caveman, as a natural man, right, in a non-civil society, right, as a natural man, only the strong survive. Okay, so if they were cavemen and they didn't have a civil society yet because they were just cavemen, then they could do things that were not desirable, right? In the natural state of man, you don't have the right to live, even though God gave you your life, you don't have the right to live. You actually have the right to kill, right? Because in the natural state of man, only the strong survives. So in the natural state of man, all of the rights that we have are rights that we don't really want. In the natural state of man, a caveman can do a whole bunch of things that we don't really want, right? That aren't desirable for a civil society. So to preserve your life, right, what we did was we created a duty, okay, an obligation. Every single law is nothing more than an obligation, okay? Every law creates an obligation. Now, a good example would be the 10 Commandments. 10 Commandments doesn't say, thou shalt have the right to live. No, the 10 Commandments says, thou shalt not kill, right? Which means that that's a duty. It's an obligation that God created. Each of the 10 Commandments commands you to do something which is a duty, right? Doesn't say that you have the right to own your property. It says, thou shalt not steal. Thus, it creates an obligation. Every law creates an obligation. Doesn't create and so an obligation can be seen from two different perspectives. From the one bound, the obligation is a duty. From the one entitled, the obligation is a right. So every law creates a duty and a right. So if I want to preserve the right to own my property, I create a law that says, thou shalt not steal, right? And as a result of that law that thou shalt not steal, I don't have the right to not have my property stolen until someone breaks the law, breaches their duty, and steals from me. Now my right to not have my property stolen has been violated as a result of the breaching of the obligation or the breaching of the duty. Every law creates an obligation. So for instance, you know, that thou shalt not unalive, right? We create a law that says here in America, you cannot unalive someone, right? Now we preserve the right to live because we have a law that says thou shalt not unalive, okay? So if I break the law, if I breach my obligation, I breach my duty, and I unalive you, then your right to not be unalived has been violated. But you can't claim that you have the right until you first show that someone has a duty and they bridge that duty. The reason why I bring this up is because in the case of the grand jury, right? We can't claim that we have the right to the grand jury until we show that the states have the obligation or the duty to provide it, right? Because the duty comes before the right. So in the doctrine of duties and rights, and if you guys, you get anything from me, right? This is probably one of the most important things you can ever get. This is $250,000 worth of education right here thrown at you. In the doctrine of duties and rights, rights always derive from another's duty to act, okay? So where there is no duty, there can be no right, okay? Now, there are duties that exist that don't have a right, such as duty to God, duty to spouse, or duty to country. I have a duty to obey God, but I don't get anything because of that duty, right? I just have to obey God, because God says obey. So there are no corresponding rights that exist for my obligation or my duty to obey God. But there are no rights that exist without a corresponding duty, because you must have a law in order to have the right, okay? Yes, we have the right to live. Yes, we have, but you can't claim that your rights have been violated until you first show that there is a law that binds someone, that creates an obligation or duty for someone to forbear or do it, okay? So rights always derive from those duty to act. There are no rights that exist without a corresponding duty, okay? So such as in, let's look at the main body of the Constitution. Articles 1 through Article 7. It's the main body of the Constitution. Now, Articles 1 through 7, what they do is they establish the obligations of our government, right? Obligations of government. So, for instance, in Article 3, where it says the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. Is that particular statement, is that provision, is that a right to a jury trial? Or is that a duty to provide a jury trial? Guys, that is a duty. Again, what it says is that the trial of all crimes, with the exception of impeachment, shall be by jury. That is an affirmative statute. It's affirmative, directing someone as to the way in which they adjudicate a crime. That doesn't say that the right to trial by jury shall not be infringed, right? Such as it does in the Sixth Amendment, right? It says that the trial of all crimes, with the exception of impeachment, shall be by jury. So that's an obligation of government, okay? And it directs them that the only way that you can adjudicate a crime, except for impeachment, is by a jury trial, a trial by jury. It's the only way you can do it. So that's an obligation. It's not a right, okay? So the reason why I bring this up is because the reason why the duty comes before the right is this. Again, the main body of the Constitution, Articles 1 through 7, establishes the obligations of government. That's the law. So if government has the obligation or the duty to adjudicate every crime except for impeachment by a jury trial, then that means that they can't do it any other way, right? They can't do anything other way. So the first step is that you cannot. So the main body. Sorry, I was reading something down here, guys. Sorry, I got to stop reading because that confused me. So the main body of the Constitution, Articles 1 through 7, that establishes the duties of government, right? Duties, the obligations of government. Now, in Article 4, they allude to the existence of rights. It's the privileges and immunities provision of Article 4. And what it says that the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. Now, that doesn't say that you have any right. It says that there's an existence of some, but it doesn't say what they are. That's because Articles 1 through 7 only has duties. Nowhere in Article 1 through 7 do you find any rights. They're all duties. And that's very, very important, because the main body of the Constitution, Article 1 through 7, that was adopted and ratified by the people on September 17th, 1787. Then the Bill of Rights, which are your rights that are inherent, that was adopted and ratified by the people on December 15th, 1791, which means that the duty comes before the right. Government accepted the duties of the Constitution before the rights were created. Thus, the duty must come before the right. So that was the reason why rights always derive from another's duty act. That's why the duty comes before the right. So if that judge were to say to you in that courtroom, if they were to say to you, do you want to give up your right to a trial by jury and enter into this plea? That judge can't ask you that question, because in order for you to give up your right, the duty must come first, right? Therefore, the judge must breach their duty in order for you to give up your right. They're inalienable. You can't give them up because the judge has the duty of fulfilling the obligation. And if you were to give up your right, well, the same argument can be made. Okay, so what if this person gives up his right to live and permits me to unalive him? Does he have the right to give up his right to live and allow me to unalive him? No. So how could the judge allow you to give up your right when their duty comes before your right? Right? I mean, the judge says, "Oh, well, you're going to give up your unalienable, you're going to give up your constitutional right and allow me to break the law," right? I mean, it's the same thing. I mean, if I go out and I unalive someone, and then I come back to that proceeding and say, "Oh, well, they gave up their right to live," right? Thus, I had the right to be able to do what I did. It's not true, right? That person can't give up their right to life. Therefore, I can't unalive them by breaching the law. It's the same argument here, guys. So, grand jury, guys, it is the first part. It's extremely important. All right. So the purpose of the grand jury is to, and this is again based upon historical facts, right, written by Blackstone. The purpose of the grand jury is to protect the accused from hasty or malicious charges by an overzealous prosecutor. So the purpose of the grand jury is to protect the defendant or the accused from the prosecutor. That's the purpose. The purpose of the grand jury is to protect the accused. So that proceeding is there actually for the accused, not the accuser, right? That's a proceeding that's there for their benefit. So when the prosecutor prevents you from being present to benefit from the proceeding that exists for your protection from the person denying you the right to be present, which is in 99% of the states that do conduct a grand jury, the accused is not present, that would be an abuse of process. That is not the purpose of that proceeding. That proceeding is not there to be ran in silence so that the prosecutor can present their case, right? That proceeding is there for the protection of the accused from the prosecutor. That is an abusive process. You must be present in that grand jury to confront the hearsay accusations against you from that person that is apparently denying you the right to be present. Now, that's if they had a grand jury, which we'll address that, but more than 700,000 people currently imprisoned here in America never even received a grand jury at all. Now, the way that the laws are written, it says that the prosecuting attorney can choose to charge by information or indictment by their discretion. Guys, let's think about that for just 1 second here, right? Let's think about that for 1 second. The prosecutor can use their discretion to decide whether or not you get a constitutional right. Okay, so first off, that's a violation of the 14th Amendment Equal Protection Clause. No state shall create any law that does not provide equal protection of the law. So when the state creates a law that says prosecuting attorney, you get to decide who gets a constitutional right and who does not. Well, now we have a violation of the Equal Protection Clause. It's also a violation of the 14th Amendment's Privileges and Immunities Clause. No state shall create or enforce any law that shall abridge the privileges and immunities of United States citizens. The privileges and immunities of United States citizens are at a minimum those that are enumerated in the Bill of Rights, the first 10 amendments. They cannot be impaired. Thus, the state has created a law that abridges, and then they enforce it through the prosecutor, a law that is abridging the privileges and immunities of United States citizens. There's no denying that, right? But more importantly, the emolument violation is you cannot pay someone to break the law. So when you create a law that permits the prosecuting attorney to use their discretion to break the Constitution, well, there's the emolument violation, right? Prosecutor, with regard to a constitutional obligation, discretion can never be used because discretion would be used abusively to break the law. You must obey the law. Discretion can be used with regard to one's powers, but discretion can never be used with regard to one's constitutional obligations because you cannot use discretion to abridge a constitutional obligation. So those are three issues, key issues that we have, right? Constitution requires it. State created a law. We don't care why the state created a law. The state created a law and is enforcing it that abridges the privileges and immunities of United States citizens. The state created a law that is allowing for one person to be protected by the Constitution and not another person by the discretion of a public official. We have a law that was created that directs someone to disobey the Constitution, thus emolument. So all three levels of those would all nullify and render void any one of these state statutes that's directing them to disobey the law. Every single one of them. Okay, every one of them. And thus we have 700,000 people that are currently imprisoned based upon an arrest that was unconstitutional because of an unconstitutional state law. Right? This is a big deal. It's a huge deal. And so, so the purpose of the grand jury is to protect the accused from hasty or malicious charges. If you did not have a grand jury, if you were charged by way of information, right, which happens in every single state, right? Every state allows for their prosecuting attorney to choose to charge by information or indictment. And then 99% of all cases, the accused isn't present in that grand jury, both unconstitutional. But if you're charged by way of information, you were denied the right to benefit from the proceeding that exists for your protection from the very person that denied you the protection that the Constitution has to preserve your individual liberties. Okay? So no matter what happens at this point in time, you guys are those 700,000 people currently imprisoned, and the number's much higher because we have 10 million pre and post conviction. I would say that probably 3/4 of them are charged by information because these states are ramping it up. Like 20 years ago, they were still running some, partial grand juries. Now they just across the board, they've trained all their prosecutors that just everything is by information now. Everything, right? In a lot of states. So, but nonetheless, so we have 10 million people pre and post conviction, 2.9 million people currently sitting in prison. Of the 2.9, we estimate over 700,000 of them were charged by information originally that never even received indictment at all. Those are direct facial constitutional violations. That means that their conviction is wholly void, without force or effect. It does not exist. There's nothing keeping them there in that prison except for a bunch of goons with guns, because there is no judgment, because that judgment can't be valid because of the direct breach of the enumerated constitutional obligation by the state when they enacted a law that is unconstitutional on multiple grounds and multiple levels. But in order for us to do this, right? In order for us to do this and to finish this, we have to go to the top, okay? The Supreme Court of the United States is going to have to address this, okay? We are not going to get relief out at the state level because these state judges are all being permitted to do it this way. The only fight that we have, the only one that could possibly fix this would be the Supreme Court of the United States addressing this, right? Choosing to act constitutionally, lawfully. That's what's necessary. The highest court in the land must create edict that directs all the judges in the land that they must obey the Constitution of the United States. So if we can get the highest judicial officer to do that, then by their choosing to act in a lawful manner, then all of their agents will also have to turn and act in a lawful manner. It's the only fight that we can win and get this addressed. No state will fix this. They may not. And you guys, I'm telling you guys this because I believe in America and I believe in the Constitution. I swore an oath that I would support and defend it 26 years ago. I will live up to that oath. And I might be a fool. And this may never work. We may never find a single justice that will ever acknowledge this or fix this or be honorable. That may happen, you guys. But I cannot give up in what I'm doing, because if we can't believe in the Constitution, if we can't believe in its supremacy and its power and its the words that it says, if we can't do that, then we can't believe in America, because the only thing that makes America America is the Constitution of the United States. Nothing else connects these states together. So if we want to fight for our nation, this is the fight that we must get in. This is the fight that we must level, because nothing else will save this country but for the preservation of that Constitution. And I would rather be a fool believing in America and believing in justice. I would rather be a fool than to accept mediocrity or the status quo and give up on that which I love. Okay? I will fight until the day that I'm proven wrong. I will fight until the day that I have no more breath. I will fight until the day that God calls me home. But I will not give up on this fight, because if I do give up on this fight, then by giving up, I will have given up on this nation, and I'm not going to do that. So we may not find anybody honest in that Supreme Court. I don't know, but all that I know is that this is what the Constitution says we must do, and I'm going to follow it until the day that I'm proven a fool. All right, and I would ask you guys to please do the same, because the Constitution, if we can't believe in it, then we've lost our country. And I do not want to live in a world that does not include America, because this is my country. And so I'm going to continue to do that. Okay. So you're right. But at the end of the day, my faith tells me that we're going to be able to save this country, because until the day that this country cannot be saved anymore, I will continue to fight for it. So, you guys are welcome to have those beliefs and those thoughts. You're welcome to say that. But I won't share and subscribe to such a theory, because I believe in our country, and I believe that this will work. I believe in those justices. I believe in this justice system. I believe in our law. And if I'm a fool, then so be it. But I'm pretty certain that God does not create fools, because that's what Scripture says. So I'm going to continue to fight until the day that my faith is proven to be foolish. Okay. So, where was I at? Any grand juries, doctrines of duties and rights. I don't remember where we were at. So let me go into Article 3. So Article 3 is what we're really arguing, guys. Anybody that follows me should know that we're not simply arguing indictments, guys. Right? We're not simply doing that. That would be too easy. That would be too simple and straightforward. What we're actually arguing is grand juries, or original jurisdiction. So the grand jury is a big enough deal that we can get in to have an argument. But the grand jury issue, if you think about it, what is the real root issue there? Is it not the state or an agent of the state bringing accusations against you and the judge overseeing that disposition of that dispute? So when you're charged by information, it's the prosecutor, who is an agent of the state, is bringing an accusation against you on behalf of the state. That's why it's state of whatever versus you. So the root issue is not the absence of the indictment. The root issue is, can a state be both accuser and judge in the same cause, right? Because that's really the root issue. Yes, indictment is a big problem, but indictment illustrates the bigger issue, because when you are not charged by indictment, when you are charged by information, that is an agent of the state, a prosecuting attorney, who is bringing an accusation against you for on behalf of the state, and then it's the state that is acting as a judge against you. So the issue is not the grand jury. The issue is, can a state be both accuser and judge in the same cause? The answer is no, absolutely not. Because Article 3, Section 2 of the Constitution bars such action. Article 3, Section 2 of the Constitution, what it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Okay? It's right here. Article 3, Section 2. Right there. In all cases in which a state shall be party. Right here, guys. Where are we at here? Okay. In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Guys, the Constitution under Article 3, it creates two different jurisdictions for the United States Supreme Court. Two different jurisdictions. One is original jurisdiction. The other is appellate jurisdiction. Okay? So original jurisdiction means that that's the court to act first. No other court in the country can act before the court that has original jurisdiction, because that's the original court. Constitution, right after that, says in all other cases of equity in law, the court shall have appellate jurisdiction. Okay? So in all cases in which a state is a party, the Supreme Court has original jurisdiction. In all other cases of equity in law, the court has appellate jurisdiction. We're all very familiar with the Supreme Court of the United States' appellate jurisdiction because we invoke it every day. We go to that court and we say, court, please review this lower court decision because we believe that it's a court of last resort. We don't believe that it's the court of first resort, right? We don't believe that it's the trial court because never in our lifetime has that court ever been a trial court. That's because original jurisdiction was last invoked in 1890, right? This is something that's been forgotten, right? Because the Supreme Court has gone about changing the narrative, changing history. But if the Constitution says that that court is the court of original jurisdiction, then that means that no other court can have jurisdiction before that court takes action. And there's two instances in which the Supreme Court has original jurisdiction. That is, one, anytime a foreign dignitary is named a party, or two, anytime a state is named a party. If a state is named a party, then that means that the Supreme Court has original jurisdiction. Now, guys, in every case, there's two parties, right? There's a movement and a respondent. There's a petitioner and a defendant, right? So in your criminal matters, who is the moving party? In every case, read your case. What does it say? State of Washington versus you. State of Colorado versus you. State of New York versus you. The state is named a party. And if the state is named a party, then that state does not have jurisdiction because the Constitution says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. The Constitution created the obligation. The only way that this obligation can be changed is through an authentic act of the people in accordance with the special amending procedure of Article 5. Article 5 tells us how to change it. And if the Supreme Court of the United States doesn't like having to be the original court, the trial court, when a state is a party, that's fine. The Supreme Court, the judiciary, could present their case to the people of the United States and get the people to create an amendment in a lawful manner. And if they don't, then there is no change to the Constitution. So the Supreme Court has never actually changed that. That was changed by the United States Congress in the 1935 Judicial Reform Act. 1925 Judicial Reform Act. So in the Judicial Reform Act of 1925, United States Congress came out and did two very, very key things to cover up this right here, to cover it up. The first thing that they did is they said that the Supreme Court of the United States and all state Supreme Courts are now courts of discretion, right? Meaning that the court can use their discretion to choose to hear a case or not hear a case. They don't have to hear a case because they're now a court of discretion, okay? So that's the first thing that the United States Congress did in that Judicial Reform Act. So they said the court can now use discretion to decide whether or not to hear your case. So we all believe that the Supreme Court of the United States is a court of discretion. We believe that they have discretion to decide whether or not they want to hear your case or not. Well, even acts of Congress must comply with the Constitution or else they are unconstitutional. So the Supreme Court can be a court of discretion so long as a foreign dignitary is not named a party or a state is not named a party. If a state is named a party, then the Supreme Court of the United States has an obligation codified to oversee that because the Constitution created it. So they can't be a court of discretion because, again, you cannot use discretion with regard to one's constitutional obligations. Obligations must be performed. So if the court could use their discretion to decide to hear a case in which a state is a party, that would be an abuse of discretion to break the Constitution. And Congress can't direct them to be a court of discretion. So when you go in and you invoke Article 3 under original jurisdiction and you say state is named a party, you must hear this Supreme Court. You're not going in there asking them to hear it. You're going in there saying you have a lawful obligation to do it. Now, do you want to break the law, Supreme Court? So the Supreme Court has no authority to use discretion because discretion would be unconstitutional. So this again goes back to what I said. If the judges are relying upon an inferior United States congressional act to abridge their constitutional obligation, that's the same issue as these prosecutors relying upon inferior state statute to deprive person of right guaranteed by Constitution. You have the right to be heard by the Supreme Court of the United States if the state is a party in your cause because the Constitution of the United States has created the obligation for them to do it, right? So when they fail to fulfill their obligation, doesn't matter why they did it, doesn't matter who told them that they can do it, right? Because ignorance of the law is no justification for having broken it. Supreme Court of the United States, you do not have the authority to rely upon an inferior United States Congress statute that directs you to abridge your obligations codified in the Constitution of the United States and United States legislature. You don't have the authority to be able to pay them to commit those crimes, right? Thus tying in the legislature like we were talking about in the beginning. So that's the first part. Now, the second thing that Congress did that made us forget about this is, one, again, they said that they're now court of discretion. But the second thing that they did was they said that from now on, the only way that you can petition the Supreme Courts is through a writ of certiorari. Right? Writ of certiorari. So a writ of certiorari is a request to review a lower court's decision. A request to review a lower court's decision. So if you bring a writ of certiorari to the Supreme Court of the United States, what you're saying is that there is a lower court decision that exists and we would like you to review it. That is invoking the court's appellate jurisdiction. Because how can you invoke original jurisdiction if the only way that you can go to that court is by saying, oh, there's already a decision made, right? So Congress made you forget about the whole original jurisdiction, the existence of it, because they said, oh, the only way that you can go to the Supreme Court is through their appellate jurisdiction. Thus, they legislatively foreclosed upon our ability to be able to use original jurisdiction because they told all of you the only way that you could petition them now is by going through their appellate jurisdiction. Therefore, you can never invoke original jurisdiction. That's why we had to go and had to find a different writ, a different mechanism to be heard. That's why we use the habeas corpus as opposed to a certiorari in this, is because if we used an existing case, all we would be doing would be invoking the court's appellate jurisdiction. And no, we want their original jurisdiction. We're not going to go to that court and say, oh, well, there's already a decision made. Please review this lower court's decision. Because no, we're going there saying that state had no authority to be able to do anything at all. Therefore, all action of the state is unconstitutional. That's why we're using the habeas corpus, is because the state never had the authority to even perform the arrest, right? They had no authority to do any of this. That's why original jurisdiction is what we're using, because if we can show, right? If we can show that a state has no authority to be able to be both accuser and judge in the same cause, then that means that if we win that argument, by that argument, every single case in which the state was a party would be void instantly, right? By that edict from the Supreme Court of the United States, all of those judgments would be void. Now, this isn't just criminal, right? This is also family court matters. This is also this is every case in which is adoption, right? Because in the adoption cases, it is an agent of the state or the termination of parental rights. In every single one of those cases, it is an agent of a state that's accusing you of being unfit to be a parent. Therefore, can the state be both accuser and judge in the same cause? And no, they can't, right? So we're able to argue the absence of the indictment issue in order to get the judgment or the action in place to be able to secure lots and lots of different fundamental rights that have been deprived, including your right to have a relationship with your children, including your right to be able to use your property without governmental interference, and so on. Because if the state is the accuser, then the state cannot be the judge, right? And for instance, in the case of your right to travel, who is accusing you of unlawfully driving? Well, that would be an officer. That officer is an agent of state. Great. That agent of state cannot be your accuser, and the state also be the judge, right? They had to bring you in front of a jury, right? And that jury, the people had to make the determination as to whether or not you were exceeding the power, authority, the rights that were fundamental to you by the Constitution. It's not up to a judge, law enforcement officer, executive officer to make these decisions, right? So we're using this indictment issue to have the argument for original jurisdiction. But this goes back to the doctrine of duties and rights, okay? So if the doctrine of duties and rights say that your rights derive from another's duty to act, then the reason why people fail in civil rights cases, the reason why most people fail in procedural default is because before you can claim that your rights have been violated, you must first show that someone had a duty and they breached that duty. So if we all want to claim original jurisdiction, if we all want to claim the right to not have the state be both accuser and judge in the same cause, then in order to do that, we have to first show that there was a duty. And whose duty is it? Supreme Court of the United States, because that's what the Constitution says. Supreme Court has a duty to oversee all cases in which a state was a party. Written right here. Never been changed. Upheld by the Federalist number 10, the Federalist number 80, upheld by Martin versus Hunter's lessee, upheld by the Automatic Judicial Recusal Code, upheld by the Civil Rights and Elective Franchise Code, upheld by everything that there is. State cannot be both accuser and judge, right? That means that the Supreme Court has the obligation or the duty to do it. So before we can claim that we have a right to not walk into the state's courts, we must first show someone had a duty, they breached that duty. That has to be done at the Supreme Court level. It's the only court. That's why we're fighting the Supreme Court. That's why I don't come out and help you on you guys' cases, is because we're not going to win from the bottom. We have to fight from the top. Supreme Court of the United States has a constitutional obligation to do something, and when we show the existence of the obligation by the creation of the duty, because we all have the right to be heard by the Supreme Court, because the Supreme Court has the constitutional duty to do it, right? Written right here, if the state is named a party. But before we can claim that we have the right to be heard by the Supreme Court and not have the state oversee the disposition of dispute that state's a party, we have to first show someone has a duty and they breach that duty. That's what we're doing. That's what this whole case is about. This duty has never manifested for the people of the United States because no one's taken the time to actually show that it exists. So we can argue jurisdiction all day long, but the fact but you're not going to win, because before you can argue for your rights, you have to first show someone has a duty. Okay? And that's what we're doing. So if you guys can help push me up into that court, right? And we can be heard, right? I will argue this on your behalf. I will establish the duty, and by establishing the duty, your right to then will then automatically be manifest. We fight with the law, right? We don't claim the right, we establish the law. Supreme Court of the United States has a law that they're breaking right now by an abuse of discretion, by relying upon an inferior United States congressional act that directs them to act unconstitutionally. Judges, ignorance of law is no justification for having broken it. So, but before we can say that the state doesn't have jurisdiction, we have to first show that the Supreme Court has a duty, thus negating the jurisdiction, right? And that would then void literally millions of judgments, guys. I mean, this case is so much bigger than I think that most people could ever even grasp. So that's where we're at now. So we have around 2 million. I don't know criminal affidavits as of this point. There is going to be another round of collecting of those. If you guys still want to get an affidavit in, you can go and you can download the family affidavit or the absence of the indictment by grand jury affidavit. You can download either one of those from justicewithoutlimits.org. Justicewithoutlimits.org. You can go there. Guys, the only post office box that's still open is the one in North Carolina. That's the only one. So there's an instruction sheet that you can download from justicewithoutlimits.org, and in it includes the post office boxes. You guys will want to send those to the North Carolina post office box. That's Justin Carey, Senior Chief Carey, United States Navy, retired, and we want to say Brother Carey's son was just killed a couple weeks ago by tyranny of the police. So our hearts go out to you, brother, and your family, your loss, Justin, your son. So Justin Carey Jr. He was killed by the police. So we want to say, sorry for your loss, brother, and we're here for you. So, but that's the only place that we'll continue to receive. Okay, so if you guys want to get us an affidavit, you guys are more than welcome to send those. But there's going to be another round, I'm sure, to get us even higher. Right between now and September 1st, when we actually go back to the court. So we don't want to go too early, you guys. We don't want to go too early. So this is about timing right now. And if when I was in Washington D.C. on June 6th, if they weren't responding then, it wasn't the right time for me to go in and deliver anything, because if we go too early and that court ignores, then unfortunately, we will have shot ourselves in the foot. We don't want to do that. So if they're still ignoring us, then what I say is we're going out and we're going to make a little bit more noise, right? So this is about timing, right? It's about timing. And if anybody has a problem with timing, and if anybody, wants to not follow me anymore because you think that I should go on someone else's timing or your scheduler, I don't care. You're welcome to not follow me anymore. I will go the moment that God leads me to go, and we're not going to go a second earlier, right? I will go when this is ready and when it's made ripe. And so right now, our new target date is September 1st, which is the day that the Supreme Court returns from summer recess. So that's our next target date. Now, again, all these are target dates. But if that target date comes and we don't have any momentum because, there's not support or, whatever, if we don't have enough momentum, that won't be the date either. I will continue to wait, because we have to make sure that we go when we have the power and the backing that we need to prevent that court from ignoring this any longer. They will make the decision, and it will be consistent with the obligations that they have codified in the Constitution. We don't have to worry about that. They will make the right decision. But this is about timing, and we're not going to go early on it. We're going to go at the right time, and the right time is the moment that we know that we have the backing that we need to prevent this from being ignored. Okay, they're not going to ignore this next time we go. Okay, so again, we have roughly 2 million of these. These affidavits are very, very simple. You guys know that. And what it is it says that you guys have been denied a fundamental constitutional right under the authority of an inferior state statute by a person in position of authority, and that is the crime of deprivation of rights under color of law. Title 18, subsection 2.2. Then there was a conspiracy was established when a judge chose to conspire by and between that agent of state, CPS, prosecutor, law enforcement, whoever. There's now a conspiracy to deprive rights when that judge made a decision in that judicial proceeding to conspire by and between the agent of state to advance the interests of the state, its master, thus, the whole conflict of interest and everything else. So these affidavits establish those crimes. That's it. That's all we need. And by showing that there was an obligation, right, and that obligation, constitutional obligation, and that constitutional obligation was breached by a person in a position of authority by the state by relying upon an inferior state statute, again, that is a per se crime based upon prima facie evidence. Affidavits are sufficient for prima facie evidence, meaning that we don't need any more evidence. All elements of crime have been met the moment we show that they had a constitutional obligation and they breached that obligation, right? All elements of crime have been met as of that moment. And by the way, affidavits do not require notary, because federal affidavits under federal law, because I'm not dealing with state law, so other people might, Phoenix Kai or Gunner, they might be dealing with state laws. I don't deal with state laws. I'm at federal level. And federally, every single one of these federal affidavits against the federal crimes that are being committed by the Constitution, none of them require a notary, because federal law allows for you to sign outside of notarization as long as it's signed under penalty of perjury. That's why the affidavits all state at the end, I do swear under the laws of or under the penalty of perjury and the laws of the United States that the foregoing is truthful, factual, correct. So you don't have to notarize a federal affidavit. You might have to notarize state affidavits, but we're beyond states. We're not dealing with that. We're at the federal level dealing with federal laws, not state laws. So anyway, so there's no need to do that. That's why we don't notarize them, is because that's a state issue, and we're beyond states, guys. All right. So one of the things that I've been saying in these services, you guys, one of the things I've been saying is that when I notify them of what's going on, right? When I notify them of the situation, then I say to them, listen, I know you guys are going to go and you're going to ask your city attorney or your county attorney after we're done here whether or not what I'm saying is true. And that city attorney is going to say to you, well, not really. And they're going to point to a case from 1884 from the Supreme Court called Hurtado versus California. Right? Hurtado versus California. And I'm informing them that before you choose to rely upon that as the foundation, I want to remind all of you that the Constitution of the United States of America is the foundation, not a judge-made ruling. Right? The reason why is because, once again, judges have no authority to legislate, meaning they have no authority to do anything with laws. Judges create rulings, not law. So all legislative power is vested in the legislative branch. That's Clause 1, Article 1. Judicial branch has no authority to alter, amend, or destroy any of the law whatsoever, because of the separation of powers. All legislative powers vested in Congress of the United States. So judges can't create law, right? Nor can they amend the Constitution of the United States, because the only way that it can be amended is through an authentic act of the people in accordance with the special amending procedure of Article 5. Article 5 of the Constitution of the United States explains how you can change the Constitution. Any other way would be an unconstitutional amendment by a branch of government that has no authority to amend the Constitution. So when the Supreme Court of the United States in 1884 came out and said, state of California, you don't have to do what the Constitution of the United States says you have to do, what they did was they amended the Constitution of the United States through judicial fiat, through a ruling, placed it at the foundation, erroneously and unconstitutionally called it law, and then told the states, you now obey our ruling that we've now told you is law, in violation of the Constitution of the United States of America. Then those states all said, well, that sounds pretty good. We didn't want to have to do the grand jury anyway because we wanted to proliferate the slavery institution. So we're going to rely upon your unconstitutional ruling that was erroneously called law, that amended the Constitution of the United States in an other than lawful manner. And we're going to create our inferior state laws that says that we don't have to do it in violation of the Constitution of the United States. And then they started going out and enforcing that inferior state law in violation of the Constitution of the United States. And now, as a result of that unconstitutional state statute that they erroneously called, that was created under the erroneous judicial ruling that was unconstitutionally called law, that amended the Constitution in other than lawful manner. In doing so, every single contract that these states are creating are all based upon an unconstitutional state statute that was created based upon an unconstitutional ruling that was erroneously called law by a branch of government that has no authority to create law, nor do they have the authority to amend the Constitution of the United States, because only the people can do it in accordance with the Constitution of the United States of America. That's where we're at. That's where we're at. So that's what we're informing them. Before they choose to rely upon a judge-made ruling as the foundation, I want to remind them that the Constitution of the United States of America is the foundation, not a judge-made ruling. Supreme Court of the United States has no authority to alter, amend, or destroy any of the provisions or guarantees of the Constitution, because that must be done by an authentic act in accordance with in accordance with Amendment 5 or Article 5 of the Constitution. All right? So, another thing I want to say here is, I am not saying that these are good people, okay? I'm not saying that these are lawful people, but what I am saying is that these were all rightful people that all had a right that has clearly been abridged by these states. And as a result, I am saying that they're not guilty people, right? Because guilt is a process, and we must follow that process. And if we do not, there cannot be guilt. Even Scripture says that. 2 Thessalonians clearly says that where there is unlawfulness, there cannot be guilt. So where our government is acting unlawfully, there cannot be guilt. So I'm not saying these are good people, but I am saying that these are not guilty people. And so as a result, what are we going to do with 2.9 million people currently forced into involuntary in a for-profit business for the direct benefit of the state? Right? What are we going to do about them who are not there on any that has any constitutional validity whatsoever? You can't have a presumption of the court, because the presumptions are based upon abridgment of the obligation. That's why we started out here talking about why rights are inalienable and the doctrine of duties and rights. So if you presume that someone can give up a right, like for instance, a lot of people will say, well, when you walk in that courtroom, you are giving up you're subjecting to your jurisdiction, and therefore you've given up your right and subjecting to the state. That's not true. That's not true. And the reason why that's not true is that we, the people of the United States of America, we created the Constitution in our sovereignty. We created that. The Constitution is the creation of the people, right? Jurisdiction is a creation of the Constitution, right? That's where jurisdiction came from. Jurisdiction comes from the Constitution. Then from jurisdiction, that creates the court, right? And then the court then creates the agent. So in the hierarchy, the judge is the lowest, the people are the highest, right? And that means that jurisdiction existed before the court existed, because the court can't exist without jurisdiction. So if a court or if an agent of the court calls me into that courtroom, right, without having jurisdiction to oversee it, because Article 3 doesn't give the state jurisdiction to oversee a case in which the state itself is a party, if I'm called into that courtroom and I walk into that courtroom, I'm not subjecting myself to the jurisdiction, because the jurisdiction existed before I walked in there, or it didn't exist before I walked in there. So if jurisdiction must exist as the first duty of the court, then when they call me into the courtroom, I can't subject to jurisdiction that doesn't exist, right? Because it never exists. In order for that court to be a court, it must have jurisdiction. In order for that agent to be an agent, the court must exist. And there is no ability for me to come in and subject myself to that court or give up jurisdiction, because jurisdiction is the first duty of that court. Before that court can even exist or call anyone in, it must have jurisdiction. Absent jurisdiction, it has no authority to do anything. Therefore, anything it produces is without force or effect. And that's ultimately, where we're fighting here, is that if the states did not have jurisdiction to oversee a case in which the state itself is a party, we have 2.9 million people currently sitting in prison on nothing. There is absolutely nothing holding them there, because there is no judgment, because that came from a court that wasn't a court, from an agent that wasn't an agent, because the Constitution didn't grant the state the ability to be able to do anything, right? So it's this is an opportunity to nullify millions and millions and millions of cases, you guys, millions. I mean, this is a huge, huge deal. So if you guys want to go back and watch some of this, if you guys came in at some point here, you can go to my YouTube page. It's there. We recorded it, so you guys go into YouTube. You can watch there. You can also go over my Facebook page. It's available there. So if you guys want to watch it, you can. Facebook, you're about to fall off here. So I'm gonna end here. You only have 1% left. So if you guys want to go back, then go out and it's not another sovereign citizen argument, but good luck with life there, brother. So thank you guys so much. If you guys want to donate, if you guys want to see this continue, please donate to the proper account. We have Cash App, Chime, Venmo, PayPal. They're all exact same. We shall be free. That's WESHALLBEFREE. Please be aware of fake accounts and scammers. Guys, if you're asked to donate based upon an email or a message, I have never asked anybody for it. This is the only place I do it. I ask you guys from here, if you guys want to donate, you guys like the service I provided, you guys want to see more of it, I would welcome whatever blessings. Jen and I, or Jessica and I, we would both welcome these blessings. Please keep them coming. Thank you guys so much. God bless. And I will review all these comments, and we will, I'll try to respond to some of them. We're back at it next week. Again, we are trying to raise as much noise as possible so that court, when it returns on September 1st, can no longer ignore us and have to address this. And I think that with you guys' help, getting out there, serving your local city council, your local county commissioners, with us out here on the road doing it, I think we're going to be able to make it happen. That is my faith. I believe in it. I will continue to fight for it, and I will gladly be called a fool if it winds up not working. So thank you guys so much. God bless. Have a great rest of your day, okay? Thanks, guys. Thank you, YouTube. Appreciate it so much. Thank you guys so much. Thanks, guys.